Today, as Rachel mentioned, going to talk about the use of technology to find solutions to delay in grievance arbitration. So in terms of giving us a brief overview, I'll give you a bit of a background about what grievance arbitration is, just a very brief background, which Rachel doesn't need by the sounds of things. And I'll talk about the problem of delay, and I'll talk about the use of technology as a methodology to study the problem of delay in grievance arbitration. And I'll just quickly go over at a high level some of my findings and some of the recommendations that come out of this study. So anyway, in terms of a background, there is, you can think about grievance arbitration, and you might think it's odd, but you can start with a bit of an Olympic slogan where it's faster, higher, stronger. And so when grievance arbitration was first conceived of, it was thought of as being faster, cheaper, and simpler in terms of a way of resolving workplace disputes. But just like the Olympics have been, in terms of their ideal, have been corrupted, the ideal of arbitration as a fast dispute resolution system is kind of open for an open question in terms of whether or not it's actually faster or not, and that's one of the reasons why I'm doing this study. So in terms of the kind of what's motivating this study, can start with an excellent quote from Justice Warren Winkler, who is then Chief Justice of the Ontario Court of Appeal in 2010, where he basically expressed his profound concern with some of the problems with grievance arbitration. And he says, "My thesis is that labor arbitration, as we know it, that institution that we are all so dependent on in the field of labor relations, has lost its course, has lost its trajectory, has lost its vision. It is at a risk of becoming dysfunctional and irrelevant." And so what labor arbitration is, for those of you who don't know, it's supposed to be basically a dispute resolution system, and so this in some respects relates to a technology of justice for workers in terms of resolving disputes on an expeditious basis. Now, what has happened is that there is evidence that the last empirical studies that were done on the issue were done more than 20 years ago. And so Warren Winkler's comments really kind of renewed the interest in studying the causes of delay in grievance arbitration. And so my study is meant to study from a scientific way the gaps, this kind of gap in the literature, and what are the modern causes of, current causes of delay. So to give you an idea about the kind of problem of delay, it really relates to the whole kind of euphemism of justice delayed is justice denied, right? And so there are several reasons why delay is a problem in grievance arbitration if there is in fact delay, and the evidence, the empirical studies, do really indicate that there is. So what you can do is you can track the number of days from the filing of the grievance until something goes all the way to a arbitration award. And what is troubling is the dramatic increase over time in terms of the average number of days that grievances are taking to get resolved. So it starts from around 200 days in the early 1970s and has now gone up to as high as about 500 days by the mid-1990s, which was when the last empirical studies were due. And this suggests basically an increase of about 120 days per decade. Which is quite alarming. And so you may say, well, okay, you're still not telling me what the issues or problems are with delay. And there's really kind of 6, which I'll just summarize quite quickly. One is that there's strong evidence that delay may actually change the result that an arbitrator gives in a case. Second is that certain remedies available to workers may become moot with the passage of time. The third is that there's a lot of evidence to suggest that delay is very harmful to labor relations. Fourth, that the liability of employers can actually increase over time. If employees get reinstated, the longer this drags on, the more money that they're going to be paid when they get reinstated. Fifth, the availability of evidence fades. And sixth, that delay is associated with increased costs, both for basically all involved parties. So, in terms of how I'm studying delay, one of the things that I used quite heavily is technology, right? So you can view the technology in this on two levels. One, you can view the grievance arbitration system as a kind of a technology of justice, but you can also view technology as an available methodology to study the delay. And there's really two ways from a methodological standpoint that I used technology. One is that I searched databases to take slices over the course of 2 decades, random samples of arbitration cases, and you needed to combine, not any one database is absolutely comprehensive, but you can combine 3 databases. This is a picture of the Westlaw Next service, which is now called LaborSource. There's also Lexis Advance, formerly known as QuickLaw, and Canly, which is a publicly available system, and you kind of need to combine those because each one has slightly different cases in it, and you can extract certain key information from that, including, for example, like when the hearing was, and then down below what the date of the grievance was. These cases have kind of a rich description that will provide a bunch of variables that you can use in terms of the context of an empirical analysis, and then you can perform statistical analysis on that. So in terms of the statistical analysis, you can use, there's any number of statistical packages that can be used. So I tended to use Stata, and there's a kind of a picture of what Stata looks like, and it drastically simplifies using fairly complex statistical models. So the model that I tested and chose to use was something called the Cox proportional hazard model in terms of determining or assessing delay. And what it does, it allows one to see the impact of various explanatory variables on the dependent variable, which is time. And so in the study, one dependent variable, which is time, and roughly about 30 independent variables. Now, in terms of the findings then, one of the things that I found through this statistical analysis is that there's really kind of 3 constructs that are useful in terms of understanding the whole issue of delay. So one is legalism, and legalism has been kind of defined in the labor relations community as the emphasis of procedural rules and legal principles over considerations that might foster the parties' long-term relationships. Another one is expanded jurisdiction, because there's been several Supreme Court of Canada cases over the last 20 years that have dramatically increased the range of legal issues that can be arbitrated. And there was a hue and cry among some academics saying that this is going to really exacerbate the delay in grievance arbitration. And last are the use of certain dispute resolution procedures that are basically meant as a check on delay. So, for example, there's a procedure called expedited arbitration that the parties may be able to use. Another example is the use of one arbitrator versus the more common, historically, 3 arbitrators to decide a given case. So, in terms of what I actually found then, this is just a very high-level summary about what the key findings were. So one of the things that you find is that the year, with the passage of time, this linear increase in delay that we've witnessed in the past from empirical studies is continuing. So in 2012, what you found is that the average duration for these grievances has now crept up to 600 days, which is quite troubling. So the delay appears to continue to be getting worse over time. And there are a number of legalism variables that were kind of statistically significant in terms of being drivers of the overall disposition time. So the use of lawyers, which by no means in the past was common across the board in terms of who were the advocates for the parties before the arbitrator, that is driving delay. Whether the arbitrator themselves has a legal background, whether they are a lawyer, is also statistically significant versus non-lawyers who are arbitrators in terms of driving delay. Not surprisingly, increasing the number of witnesses becomes a driver of delay. Credibility challenges was also another statistically significant driver of delay. Interestingly, for the expanded jurisdiction, I found that the kind of troubles that were claimed by and large weren't kind of borne out by the evidence. So although I tested employment standards issues, there were a whole range of other issues such as human rights issues, charter issues, torts issues that really had no bearing on the, statistically significant bearing on the time. But I did find that in kind of a couple of these years of study that the Employment Standards Act issues were increasing the amount of time where a case had those as time went on. In terms of procedure, what you find is that the use of sole arbitrators really dramatically decreases the amount of time taken to resolve a grievance. The use of expedited arbitration, there's a couple of different varieties. Both of them are relevant here. The use of statutory or contractually expedited arbitration both help. And interestingly, the mediation arbitration, which is a kind of a procedure where the arbitrator acts as a mediator first, actually increase the amount of time, but that's not surprising if you think about it, because the mediation for those grievances that require an arbitration step is simply one additional step in the process. So, in terms of what this means for recommendations, that one of the things to recommend to parties is to reduce legalism and focus on something that you can think of as proportionality, which is basically using lawyer advocates, arbitrators as lawyers, or other things based on the kind of complexity and importance of the matter, rather than going to the mat on every single arbitration and viewing it as a fight to the death. And one of the other recommendations is encouraging the parties to design a system that meets their own needs and basically makes use of the procedures or emphasize certain things that tend to decrease delay. And also, this does highlight the fact that there is a role for the Ministry of Labor to play here, which is really an educational role where they can educate people on the main drivers of the parties, on the main drivers of delay, and on certain kind of potential solutions and procedural things that will help. Also, one potential solution is for the Ministry of Labor to resume a program that they used to have, which was to train arbitrators who weren't lawyers to become arbitrators, and that has, I think, real potential in terms of dealing with this whole the issue of delay. And also, lastly, we need kind of more study on the whole procedure that does seem to have great advantage in terms of managing delay, assuming that you don't need to then, if it's settled, resolve at mediation, go all the way to arbitration. And surprisingly, there has been very little in Canada or the US study on mediation arbitration. So I will leave it there, and thanks for your kind attention.